Very often I need to have very detailed and sometimes difficult conversations with my clients about the limitations of the impact that conduct will have on their case. As I'm sure everyone can appreciate, when a relationship ends, very often it is easy to apportion blame, and very often someone can feel that they've been mistreated and that should be taken into account. This is not something that happens very often in English courts. However, it can happen, and so it's vital that you have solicitors and lawyers who are very well versed on how to use this type of arguments in order to advance your case one way or another. Especially considering funds and the division of money, the English court tends to look at conduct only pretty much in 4 circumstances. The first one is when it is something very obvious and very personal. So a classic example of this is provided within the case law. And we can see in this case specifically a husband who had physically attacked his wife to the extent that she was severely injured, and that had a clear impact on her earning capacity. She could no longer earn a living, at least not at the same level that she could before, and that was deeply reflected into the financial award that she got at the end. However, the bar is very, very high. A counterexample to that is one where you had a wife who was, of course, very annoyed about the fact that her husband had left her for someone else. She commented on the fact that it was nothing to do with her, and as such, he shouldn't get the benefit of arguing that her marriage was one that was very short and therefore her claims were diminished. The second type of cases in which conduct comes into play is when we are looking at the argument relating to add-backs. The idea of adding back is to say someone has spent quite a lot of money or disposed of quite a lot of assets, therefore they've already had a part of their cake, and when we look at dividing what is left, they should just have a smaller portion as they already had their own slice. Looking at this, we have to establish whether conduct was, whether one of the parties behaved in such a way that they were wanton and reckless. This is quite a high bar. We can't expect to meet it very often, but when that happens, the award that the court makes is very often reflective of what has happened. It's interesting to quantify. What is interesting is the exercises need to be carried out in order to quantify how much should be added back. And once again, having forensic accountants, valuers, and very experienced solicitor can make a dramatic difference in order to make sure that an add-back argument goes the right way for you. The third type of conduct argument that we can look at is related to litigation conduct. So if one of the parties is behaving in such way that is deliberately frustrating the litigation process, the court should take that into account. For example, if they're not showing up at hearings, they are hiding assets, they are once again dissipating assets in order to ensure that the other party won't have a claim in it, and more applications have to be made, more legal fees have to be spent, the court should consider that. The way in which the court generally considers it is by making a cost order against the party who misbehaved, for lack of a better word. In doing so, however, we are not looking at a difference in how the assets are being divided, but we're just making sure that any funds that the angel of the situation has not deliberately wasted but had to waste as a consequence of the misbehaving party will be reimbursed. The fourth area in which we can look at conduct is based more on evidence. So whenever we're trying to satisfy the court, for instance, that there are more assets than the other side is prepared to provide us with evidence of, and because of the very specific rules of the English court, one of the parties can't really help themselves to information, we're then starting an argument whereby we are convincing the court that there is more, the court should be persuaded that that extra is there and is available to be divided. In that way, as it's clear to imagine, you get to a point where you get a given percentage of a much larger pot, and that is, of course, much better. Equally, that argument is often run by people who are not quite as prepared as others, and sometimes it can be indicative of wishful thinking. If that is the case, and we are representing the party who is being upfront, but in reality simply there isn't anything more, at the end of the day we are incredibly well versed in ensuring that their position is presented in such clear manner that the court will not waste anyone's time in trying and doubt whether our client is lying or telling the truth.